Morning, everyone. Welcome to Myerson's Employment Law Update for this autumn. A warm welcome to those of you who've joined us in the room out for breakfast, and also to those of you joining us online. Before we start, there's just a few points of housekeeping. We'd be grateful if you could put your phones on silent. If you don't mind, if you need a comfort break or any help from our reception staff, it's best to leave through the back door, and the toilets are just on the right. There's no fire drill today, so if you hear a fire alarm, that's real, and we can leave through that fire exit just there. In terms of timing, we'll talk for just about an hour this morning, and there'll be some time after we've spoken for questions in the room. If you're online and you've got questions, there is a question and answer facility on your screen, and you can pop questions in there, and we'll pick those up after the seminar. I'm joined this morning by my colleagues Charlotte Gilbert, who's partner in the Employment Law team, and Jack Gilbert, Jack Latham, who's a senior associate in the team, and the rest of the employment team are also in the room to help answer your questions once we've finished speaking. In terms of our agenda this morning, we've stayed with our usual format, and we're going to talk about the top 10 things that we feel you need to be aware of this autumn. I'm going to spend some time looking at reform and where we're up to with the Employment Rights Bill, and I'll spend the next three topics looking at the topic of redundancy. Charlotte's then going to pick up and talk about all things related to disability, and Jack's going to finish on the home straight with return to work mandates for Women's Scotland case and the prevention of sexual harassment, and where we are on that a year on from the law coming into effect. So I'll turn first to look at the Employment Rights Bill and where we are up to. It's just over a year now since the bill was published in October 24, and I think it's fair to say we're not where we thought we might be by now. It was expected that the bill would be enforced by now, but it's still struggling to get royal assent because of some dispute between the two houses of Parliament on some of the key provisions. It's in near final form, and subject to that, hopefully it should get royal assent, perhaps still this year. That said, some of its main provisions will be delayed in coming into effect in any event, and you'll know that in particular, for example, the day one unfair dismissal rights are now delayed until October 2027. So it's frustrating that there are the delays. It's probably welcome to most employers, but the uncertainty that it brings is quite frustrating. In July 2025, the government published its roadmap on the implementation of the Employment Rights Bill, and I'm going to spend my first topic just looking at that roadmap, what it includes, the key points, and what the developments have been. We expected to see in 2025 some changes in relation to the law on industrial action, and the focus here was effectively to reverse the restrictions on calling for industrial action that the previous government had introduced. So those changes will be the first to come into effect, together with additional protections for those who are taking industrial action from dismissal. It's perhaps unlikely that they'll come into effect this year, but we might expect to see them come into force early next year. Looking a bit later on at next year, and a list of changes coming into effect in April 2026. The most impactful of those is probably the changes to the protective award. So the protective award is the award that is made where an employer has failed to comply with the collective consultation regulations, where 20 or more dismissals within a period of 90 days are proposed at one establishment. The change is to double the protective award from a 90-day pay award to a 180-day pay award. The logic behind that is to try and deter employers from seeking to circumvent those rules by buying the rights out under settlement agreements. And really, this will make it prohibitively expensive to be able to do that. One of the unsatisfactory points about this is that we do not yet know whether the new rules will apply to dismissals which take effect after the 6th of April next year, or those dismissals which are proposed after the 6th of April next year. So that's a big area of uncertainty. And for those planning redundancy exercises early on in 2026, that'll be something that you'll need to have an eye on. Other changes coming into effect in April are the day one rights to paternity leave and unpaid parental leave, removing the current 6-month service requirements for those rights. We'll see a clarification that reports of sexual harassment qualify as a protected disclosure for the purposes of the whistleblowing legislation. We'll see the removal of the lower earnings limit, and the waiting period for statutory sick pay, meaning that statutory sick pay will be paid earlier and to a wider group of people. We'll also see the significant changes that are coming in regarding the process of obtaining recognition for trade unions, and we'll also see the introduction of electronic balloting for trade unions. And alongside that, we'll also see the removal of the current minimum turnout requirement of 50% of those entitled to vote for the purposes of calling industrial action. That's one of the issues that's holding up the progress of the bill, because that's hotly debated between the two Houses of Parliament. Moving on later into 2026, we will see further changes. I'll come back to the new rules on automatic unfair dismissal in fire and rehire exercises. We'll see in October 2026 the rights for trade unions to request from employers access agreements so that they can access workplaces both on a physical basis and electronically to campaign and to organise and for the purposes of collective bargaining. And we'll also see the introduction of a new obligation on employers to issue a statement to workers of their right to join a union and what their rights might be. On the 25th of October, the government published 2 consultation papers in relation to those 2 issues, so a year ahead of when they're likely to come in. The duty to inform workers of a right to join a trade union has a real practical impact, in that on recruitment it will be necessary to issue a statement to all workers as they become engaged by the business. The consultation is around the form and the content and the manner of that statement. And there is a proposal that the government might prepare a template type statement to reduce the administrative burden on employers. The proposal is also, though, that that statement will need to be issued annually to make sure that employees are reminded of their right to join a union to bolster union numbers in the UK. Also, in October 2026, we will see reinforcement of the laws around harassment, a requirement for employers to take all reasonable steps rather than just reasonable steps to prevent sexual harassment, an obligation on employers to protect their workers from harassment by third parties, and we will also see the tightening of tipping laws. That takes us into 2027. Where we will see, I think, the more impactful and the more controversial changes coming into force. And there's a great deal of uncertainty about what a lot of these changes are going to look like, but there is 2 years almost to prepare. The most controversial, of course, is the introduction of the day one right to claim unfair dismissal, and that's an outstanding dispute. The House of Lords is quite insistent that there should be a 6-month qualifying period before an individual qualifies to present a claim of unfair dismissal, whereas the government is holding fast to its manifesto promise that there would be a day one right. That was discussed in Parliament just yesterday, and there is still no conclusion, and the government is still insistent on a day one, and the House of Lords is still insistent on a 6-month qualifying period. I think where we will probably land is that we will see some compromise in the rules and the rights that arise during that initial period of employment that will apply for the first 6 or 9 months of employment, and perhaps that's where the compromise might be found. We'll have to see where that debate ends. We will also see in 2027 new protections from dismissal for pregnant workers and those returning from family leave, and also collective redundancies again and the thresholds that might apply. And I'll come back to both of those in a bit more detail later on. For completeness, Other changes in 2027 will include the restrictions on the use of 0 hours workers. And again, this is one of those areas that's stopping the progress of the bill at the moment because of issues around opt-outs and also issues applying to seasonal workers. We'll see unpaid bereavement leave being introduced. So at the moment, the only bereavement leave right is for parents, and that will be widened and will also cover early pregnancy loss. We'll also see new obligations around gender pay gap and menopause action plans and reinforcement of the regime on flexible working. So the roadmap, I think, suggests to us that we have quite a long journey ahead of us and that we should expect quite a few twists and turns along the way, but we'll keep you updated around that. My next three topics all relate to redundancy. And I'll turn to those now. The Office of National Statistics has reported some data that UK unemployment is at 4.8%, and that's its highest in the last 4 years. And redundancy levels are at their highest in the last decade. And we're certainly seeing that in our caseload, and our clients are also seeing this. We're seeing lots of redundancy exercises with employers citing pressures such as economic uncertainty, increases in the national insurance contributions and increases in wages. Even AI is featuring as a reason to cause redundancies. So we thought it might be helpful to look at a few issues that arise on redundancy where there have been developments in the last few years. A fair redundancy requires a genuine redundancy situation, fair selection, consideration of suitable alternative work and consultation, perhaps both on an individual and collective basis. So I'm going to look first at the issue of suitable alternative work and a recent case reported concerning this. This involved Hendy Group Limited, which was a large car dealership with multiple sites, and a Mr. Kennedy. Mr. Kennedy had worked for Hendy Group for about 7 years in various different roles, including used car sales. He had been in management of one of their dealerships, and then he'd moved into its training academy. Beyond that, he'd had a 30-year career, primarily in car sales. So he was very experienced. On the 4th of September, the redundancy situation arose out of circumstances connected with the pandemic. And on the 4th of September, Mr. Kennedy was put at risk of redundancy. And he was told at that point that he needed to look on Hendy's intranet site for vacancies that might be available to him. Just over 2 weeks later, he was given formal notice of redundancy. So that was on the 21st of September for his employment to end on the 9th of November. And about a week after his formal notice had been given, the company took away from him his laptop, which removed his access to the intranet site and also his access to internal emails. Once he was not at work, HR hardly contacted him at all. They didn't do anything to notify him of any new vacancies that arose. He had made some applications for some vacancies and he was offered no assistance in connection with that. The company did not notify the recruiting managers for the vacant positions that Mr. Kennedy was at risk of redundancy. And just before his employment ended, Mr. Kennedy was told that he wouldn't be considered for any sales jobs because they couldn't understand his motive for applying for them. There was no dispute from Mr. Kennedy that there was a genuine redundancy situation, nor that he'd been fairly selected for redundancy from the group within which he worked. His objection was in that the company had failed to look properly for suitable alternatives for him. And he made a claim of unfair dismissal based on that, and he was successful. Hendy appealed that decision to the Employment Appeal Tribunal, which upheld the Employment Tribunal's decision that Hendy had not acted within the range of reasonable responses, having particular regard to its size and administrative resources, in that it had not made appropriate efforts in relation to the finding of suitable alternative work for Mr. Kennedy. The finding of the EAT was that Hendy had taken an approach that no reasonable employer would have taken. And so I think there are some lessons to be learned from that around the proactive obligation that falls on employers to look for suitable alternative work for those employees who are at risk of redundancy. And so based on the comments of the Tribunal and the Employment Appeal Tribunal, I've pulled together a list of the right approach when you've got somebody at risk of redundancy and where there might be suitable alternative vacancies in the business. One of the criticisms of Hendy was that they hadn't explored with Mr. Kennedy what kind of alternatives he might be prepared to consider, and they didn't understand his background in sales. So that was a failing. So having a proper discussion with the affected employee about what kind of vacancies they might be interested in, even that if that involves a demotion, is an important thing to do. Employers must make sure that the employees have access to vacancy information and additionally proactively suggest alternative posts that might be suitable. From other case law, we know that it's also important, if you are suggesting alternative employment, to make sure that you provide sufficient details around that alternative role, the nature of the role and the remuneration that goes with it. The company in this case failed to offer assistance and support applications, and that's an important part of the process. We also know that looking for vacancies in group companies is also something which employers should consider. The past case law tells us that it's not an absolute obligation to do that. It's a question of reasonableness, and it depends on the relationship between the group companies and what kind of influence the employer might have, but it's certainly something to consider. Having said that, there is no obligation to create a vacancy. In this case, Mr. Hendy might have benefited from offering to Mr. Kennedy a trial period. And one point to pick up, I think, is that the obligation to look for suitable alternative work subsists during the employment. And Mr. Kennedy was on a period of notice. Had the company decided to pay in lieu of that notice, their obligation would have ended sooner. For my next topic, I'm going to stick with the idea of redundancy and alternative employment and just look at those categories of employees who have special protection in this area because it's often an area of confusion, and also there have been some developments in recent years. So a pregnant employee or an employee returning from maternity leave or other types of family leave is a protected employee in that they have a priority in relation to suitable alternative work that might be available. And so this is a rare example of positive discrimination where the protected employee is treated more favourably than other employees who might be equally well qualified for that vacancy. So in 2024, we saw some developments in this area, extending the protected period, which was previously just the period of maternity leave, to the period from when notice of pregnancy is given until 18 months after the date of the birth. So it's a long period of protection. That was also extended to other categories of family leave, being adoption leave and shared parental leave. In 2025, we saw the right extended yet further to cover those parents who had needed to take neonatal care leave for a period of at least 6 weeks. So it's important to recognise that you have this potentially a big period of time that catches a lot of people that might have a priority in a redundancy exercise. In terms of reform, the government recognises that that level of protection for pregnant employees and those returning from family leave doesn't go far enough to address the problem that we have in terms of losing from our workforce huge swathes of women in particular who have babies and take maternity leave. The statistics are shocking, with a reported 74,000 employees each year leaving their employment for some reason connected with pregnancy or maternity leave. And so this is a real feature and focus of the Employment Rights Bill. And what the government proposes to do is to bolster the dismissal protection for those categories of employees. At the moment, the proposal is to bolster the protections for pregnant women and those returning from maternity leave. There's a question mark over whether that protection might be broadened even further to those returning from other types of family leave. So in October, this year, the government issued a consultation paper looking at the options that there are for bolstering that protection. So the first option to be considered is to protect employees in those categories from dismissal by making the 5 fair reasons for dismissal much narrower. So, for example, if there was a redundancy situation, that person could only be selected for redundancy in cases of extreme financial difficulty. Or in the case of conduct type dismissals, an employee might only be dismissed if there is a gross misconduct reason for dismissal. So in the context of redundancy, whereas now it might be permissible to select a pregnant employee or somebody on maternity leave for redundancy, as long as that's not the reason for the selection, it may become not possible to do that if these laws come into effect. The second option that the government is exploring is a higher requirement in terms of fairness in those types of cases where it would need to be necessary to dismiss the employee rather than just a reasonable thing to do, which is the current rule. So that consultation is currently open. It'll end in December, and we'll have to see what the government's response to that consultation is and how these rules will change. But there is a deep commitment from the government to improve the position for pregnant workers and those returning from maternity leave. So in terms of practical steps on this, I think if you are facing a redundancy exercise, it's going to be really important to identify all those employees who might have protected status so that you know who you need to prioritise in the event of there being an opportunity for suitable alternative work. It's sometimes the case that there are more protected employees than there are vacancies. And the practical thing to do there is perhaps to invite voluntary redundancy, or if you're in a selection situation, to make sure that you select for the post without reference to the fact that the employee has a protected status or protected leave. And I suppose the final point is to keep your eye on these changes, because when they do come into force, and however they come into force in October 2027, that's going to impact the selection of employees for redundancy who are protected. So moving on to my final topic, and sticking with redundancy and sticking with reform, I just wanted to have a look at how the reforms that we're anticipating will affect a redundancy exercise. I've already mentioned the imminent increasing of the protective award up to 180 days. What will also happen in 2027 is that the threshold for numbers triggering the requirement to collectively consult will also change. So at the moment, the triggering number is 20 employees who will be dismissed, or who it is proposed will be dismissed within a period of 90 days at one establishment, and that threshold will remain. However, there will also be a second threshold, and the purpose behind that is to try and bite those employers who are multi-sited and who might be making 20 or more redundancies, but at different locations. And what the at the moment, that wouldn't trigger collective consultation, and the proposal is that that should. And we've yet to see the detail on that. We know that the number won't be less than 20, but it may be more. And it's going to be a real headache for employers who are multi-sited, trying to keep track of the effect of dismissals on different sites. So that change will come in, and obviously that will have an impact on redundancy exercises. A change coming in earlier than that are the new restrictions on fire and rehire, and this has been a hot topic well before the new government came into power. The government has very significantly rowed back on its proposals around the restrictions on fire and rehire, and the current position is that unlike the original proposal, there'll be no interim relief available for those dismissed in fire and rehire circumstances. We're still waiting to see an updated code of practice, and there has been the employment tribunals do have power to increase awards of compensation by up to 25% in cases where there has been a breach of the code, and that will apply to both unfair dismissal awards and also the increased protective awards, so potentially very significant amount of money. Where the government has rowed back is there's been a change of approach in terms of what would be regarded as an automatic unfair dismissal in these circumstances. There'll only be an automatic unfair dismissal where the employer proposes to fire and rehire to achieve restricted changes. And those restricted changes will be changes to terms and conditions affecting pay, pension, hours, on holiday, and also an attempt to introduce into the contract a clause that says there can be further variations that are permitted by the contract. Beyond that as well, an employer will not have automatically unfairly dismissed an employee in those circumstances if it can prove that the changes were necessary because the company was in financial difficulties. And there's great uncertainty about what that will mean and how employers will evidence that to an employment tribunal. It's not something that employment tribunals currently have to consider. And it might involve, for example, expert evidence around the state of the company's finances. So the combined effect of all of that is the complexity arising out of these new laws, the increases that in compensation that will apply are making what is already becoming a very unpopular tactic an even more unpopular tactic. And the net effect is perhaps to deter the achievement of changes to terms and conditions through this route. And last but not least, one of the last things we'll see happen is the introduction of the day one unfair dismissal rights, of course, subject to further debate, royal assent, and also all the detail in the regulations. But obviously that will have a very significant impact on redundancy exercises going forward. So those are my topics. I'm going to hand over to Charlotte, who is going to pick up on disability.
So I'll be covering the next 3 sections then, which relate to recent cases on various disability discrimination points, which are just worth being aware of. So the first case relates to the meaning of disability and how a tribunal incorrectly concluded that an individual with autism and ADHD was not disabled. So before we go into the facts, I just thought I'd do a quick recap on the legal definition of disability, which is set out in Section 6 of the Equality Act. And it's also supplemented by the provisions in Schedule 1. But this test can be assessed through 4 questions. Firstly, does the person have a physical or mental impairment? That's not specifically defined, but a common sense approach should always be taken. Secondly, does that impairment have an adverse effect on their ability to carry out normal day-to-day activities? So the activities affected must be normal, not specialised or requiring niche skills. And the guidance gives examples of things like daily household tasks, walking, travelling by various forms of transport, taking part in social activities, etc. The third part of the test is whether the impairment causes substantial adverse effect, which must be more than minor or trivial. And finally, is the effect of the impairment long-term? And it will only be deemed to be long-term if it has lasted or is likely to last at least 12 months. So in the case of Stedman and Haven Leisure then, Mr. Stedman had diagnosed autism and ADHD, and he applied for a job as an animation host at one of Haven's holiday parks. He was unsuccessful, so he brought claims for disability discrimination in relation to the handling of that job application. Now, as is usually the case in discrimination matters, the tribunal listed a preliminary hearing, which considered whether he met the test of disability under Section 6. And at this preliminary hearing, he gave medical evidence of his diagnosis of ADHD and autism, as well as an impact statement setting out his disabilities in social interaction, memory, concentration, and in using public transport. But he also acknowledged that he had plenty of friends and he had undertaken a degree. Now, the tribunal accepted that Mr. Stedman had a mental impairment, but it concluded that it did not have a substantial impact on his normal day-to-day activities. And so he didn't meet the test of being disabled under Section 6. Mr. Stedman appealed to the EAT, saying that the tribunal had failed to recognise the substantial adverse effects on his ability to carry out normal day-to-day activities, such as his inability to use public transport when crowded, struggling to remember things, difficulty concentrating, and his excluding himself from social activities. And he also appealed on the basis that the tribunal had incorrectly focused on what he could do, rather than what he could not do or could only do with significant difficulty. So the EAT allowed his appeal and found that in assessing the test of disability under Section 6, the tribunal had made several errors, and it emphasised 3 key points. Firstly, that the required comparison was between Mr. Steadman's abilities as they were with the impairment and as they would hypothetically have been without it. So the correct comparator is the individual without the impairment and not other people generally. Secondly, the EAT said that the tribunal had failed to focus on Mr. Steadman's difficulties and had incorrectly weighed up his ability to carry out one day-to-day activity against another. So, for example, it had weighed his relative academic success in achieving a degree against his claimed difficulties with memory and concentration, rather than considering what impact those difficulties actually had on him. Thirdly, the EAT also specified that it's sufficient if the claimant's impairment has a substantial adverse effect on just one day-to-day activity. So his appeal was successful, and that's now been remitted back to a fresh tribunal to determine whether he's disabled under Section 6. Now, whilst this case was obviously about the tribunal getting the initial assessment of disability wrong, there are some key points for employers to take away from this. It's important not to downplay any clinical diagnosis of neurodiversity, as this case demonstrates that a clinical assessment will usually be very strong evidence of impairment under the Section 6 test. It also shows that disability assessments in the workplace and discussions with employees should focus on how the impairments affect daily life, not on how well someone compensates in certain tasks. Now, this claim arose from a recruitment process, so it's a useful reminder to properly consider and accommodate any disabilities, both in the recruitment process and beyond, and to keep accurate records as to why a candidate was not assessed as suitable for any role. And given this case is about neurodivergence, it's a good reminder generally to offer inclusive practices and support for neurodivergent candidates and employees. So this next case involves an assessment of what a reasonable adjustment is. And the duty, just as a reminder, to make reasonable adjustments is set out at Section 20 of the Equality Act. And it arises where there is a provision, criterion or practice, or PCP as we call it, or where there's a physical feature which puts a disabled person at a substantial disadvantage in comparison with those who are not disabled, or where a disabled person would, but for the provision of an auxiliary aid, be put at a substantial disadvantage in comparison with those who aren't disabled. Now, the case which has recently considered this duty is High March and North East NHS Foundation Trust. And the facts relate back to the COVID pandemic, but the principle is relevant and it's useful for employers. So, by way of background then, Mr. Hindmarch was employed as a non-emergency ambulance driver during COVID, and he was transporting patients just between home and hospital. He suffered with depression and anxiety, which was greatly exacerbated by the pandemic. He was very worried about contracting COVID, and he had an underlying asthmatic condition, which initially required him to shield. So after this period of shielding, he returned to work in August 2020, transporting patients who didn't have COVID. But in November 2020, he was asked to transport a patient who was COVID positive, and he refused to do so. So the trust gave him alternative work in the stores. Now, he continued to work in the stores department until April 2021, when he began a phased return to his substantive driving role. Then in May 2021, he was asked to transport a COVID positive patient from hospital to their home, and he suffered a panic attack, so he declined the job and went off sick. He made it clear that he wouldn't be prepared to contemplate a return to ambulance driving unless he was provided with an FFP3 face mask, which was a more robust mask only used for those having to undertake a resuscitation technique. And that's obviously something that he wasn't required to do as part of his role. And this was as opposed to being given an FFP2 mask, which is the more standard surgical mask normally issued to non-emergency drivers. And at the time, there was also national guidance that had been issued to hospital trusts saying that only those FFP2 masks should be issued to the non-emergency ambulance staff like Mr. Hindmarch. So given this guidance then, the trust refused to provide him with that more robust mask, and it explained to him that it wouldn't provide him with complete protection from COVID anyway, and that it couldn't actually be used for a full shift or for extended periods of driving. And also, Mr. Hindmarch never actually confirmed that he would be able to return to work if the more robust mask was provided to him. So the trust didn't believe that the provision of such a mask would actually alleviate his concerns or facilitate his return to work. So he remained off sick until his dismissal on grounds of ill health in September 2022. And he then brought claims including failure to make reasonable adjustments. The Employment Tribunal dismissed his claims, and in so doing, they confirmed that the trust was under a duty to make reasonable adjustments here, but that the trust had not failed in its duty to make those adjustments because there was no realistic possibility that the provision of the more robust mask would have actually led to him returning to work, given his acute anxiety about COVID. So the tribunal found that the more robust mask would not have avoided the substantial disadvantage that he faced, and it would therefore not be reasonable to make. It also concluded that the trust had met its obligations to make reasonable adjustments by offering him the opportunity to work in a non-patient facing role and allowing him a phased return to his normal role. So he then appeals, and the EAT have now agreed with the tribunal and dismissed that appeal. And in relation to the reasonable adjustments claim, the EAT reiterated that that if there is no real prospect of an adjustment helping to avoid or reduce the disadvantage, then the employer is under no duty to make it. It also said that the provision of the mask in this case wouldn't have alleviated the substantial disadvantage he faced, as the real issue for him was the psychological effects of the fear of catching COVID. And based on the evidence presented, the tribunal was entitled to conclude that providing that more robust mask would have made no difference here. So just looking at the takeaways from this case then, it underlines that the duty to make reasonable adjustments is not absolute. It depends on whether that adjustment would genuinely make a difference. And the EAT was helpfully really clear that if it would have no real chance of avoiding or reducing the disadvantage, then the employer is under no duty to make it. And they said that that's just a common sense approach. Each case will, of course, always depend on the circumstances and need to be considered on its own facts. But it's also important for employers to have that dialogue with the employee as to adjustments being sought and to make evidence-based decisions. Engaging occupational health and obtaining updated medical evidence can assist with this. And it should, of course, all be documented, especially the reasons as to why you don't consider it reasonable to make any adjustment. And then this documentation provides strong evidence of compliance with the Equality Act if that's later challenged. But there will still be a need to consider all of the steps which could be taken here, as in this case it was noted that the trust had made other reasonable adjustments through giving him that non-patient facing role and implementing the phased return. And finally, just a reminder that if an employee remains unable to return to work despite considered adjustments, then dismissal for ill health can be lawful, provided the process is fair, transparent, and supported by medical evidence. So this next case then, and the final one in this session, is another reasonable adjustments case, but it relates to redeployment, and it's a helpful one for employers to remember when dealing with a disabled employee who's unable to perform their role. So Mr. Chowdhury was employed by Network Rail as a customer service assistant at London Bridge Station. And his duties included patrolling the station, conducting security checks, reporting suspicious behaviour and helping customers, as well as occasionally working on the help desk answering customer queries. Now, he suffered from plantar fasciitis, which is an inflammatory condition of the muscles in the feet, and that affects mobility because it can be painful to stand or walk for long periods of time. And shortly after he started his employment, he suffered a recurrence of his symptoms and was absent from work. He was placed on the help desk as an interim measure. Then he had another period of sickness absence, and he was placed on the respondent's redeployment register. Now, the medical evidence from occupational health and from Mr. Chowdhury's doctor agreed that he was unfit to carry out his customer service role from July 2020 until his dismissal. But from July 2021, he was considered able to perform a sedentary role on a part-time basis. And whilst he was on the redeployment register, he applied for 3 roles as a stores coordinator, a document controller, and an HR administrator. He was unsuccessful in these applications, and following a series of capability meetings, he was given notice of dismissal and his employment ended in August 21. So he then brought claims in the tribunal alleging that his employer had failed to make reasonable adjustments by refusing to redeploy him into one of the 3 roles for which he'd applied, or into a help desk role by bumping one of the other staff members, and for not allowing him longer to find an alternative role before dismissing him. Now, the tribunal dismissed all of his claims and he appealed that decision. And the EAT has since upheld the tribunal's decision and found that the refusal to redeploy him did not amount to a failure to make reasonable adjustments, since he didn't meet the essential criteria for the roles that he'd applied for. The essential criteria for each role included relevant prior experience and strong skills in Microsoft Office. And the EAT agreed with the tribunal that it would not have been a reasonable adjustment for Network Rail to disapply this criteria, nor would it have been a reasonable adjustment to appoint him to either role, together with training to bridge the gap, since he had no prior experience at all and only very basic skills in the relevant software. It also agreed with the tribunal that redeploying him to the help desk was not a reasonable adjustment, as it would not have relieved him of the obligation to stand and walk for long periods. Sorry, just go back. Additionally, the EAT confirmed that it would not have been a reasonable adjustment to allow him longer to find an alternative role before dismissing him. And actually, by the date that he'd been off sick or only fit for limited duties, it had been over a year where he was unable to do any work. So there was no clear prognosis for his recovery, and he'd only applied for 3 alternative roles in that time. So the tribunal had been entitled to find that it was unclear whether any further delay would actually achieve anything, and they'd acted reasonably in deciding to terminate his employment when they did. So just in terms of the key takeaway here then, this is a really useful case for employers as it confirms that you don't have to redeploy disabled employees into roles for which they don't meet the essential criteria. And effectively, reasonable adjustments do not automatically override core job requirements, although each case should be assessed on its own facts. Tribunals will, however, still scrutinise whether that criteria is essential and whether or not the employee does meet that criteria. So it's important for employers to carefully consider applications for redeployment and keep that paper trail of the decision-making process. Clear documentation will always be key, and in this case, the employer had extensively documented its efforts to support the claimant's redeployment, which helped in its defence. So employers should always be prepared to provide that evidence, such as results of any tests, assessment processes, and job descriptions, etc., to support that decision that the employee did not meet the essential criteria for the role, and to demonstrate any other support that was offered. And it's also important to remember that a fair capability process should be followed, and in this case, Mr. Chowdhury had been off sick or only fit for limited duties for over a year, whilst redeployment was being considered and before that dismissal took place. So that's the end of the cases. I'm just going to hand over to Jack now for the final updates.
Thank you. So I'm going to take you through the last 3 topics. They are return to work mandates, the case of 4 women Scotland, and prevention of sexual harassment 1 year on. So let's start with return to work mandates. So this is a topic that's not going away, basically. I've spoken about this before in spring 2023, but I think the big difference between then and now is there was a real opportunity to return staff to the office, and I think those opportunities are starting to dwindle. So if you've not made the shift back to the office, it's going to become increasingly harder. That's because obviously during the pandemic, there was widespread adoption of remote working, which hasn't really gone away. And many staff feel that flexibility is now the norm and would resist a return to full-time or even several days in the office. And what this does is it creates a significant gap between employer expectations and employee expectations, creates a why from an employer point of view compared to a why not from an employee point of view. So the why, employers often struggle to talk about the why. They might talk about perceptions of lost company culture, engagement, collaboration, and without sort of real world data to back this up, these could just be meaningless buzzwords to employees. So there are things you can do as an employer to back this up, like staff engagement surveys. Has the culture of the company changed since everyone's gone remote compared to how it was before the pandemic? Productivity drops is a big one. I've talked about concerns about potential productivity drops, but is that actual productivity drops? Is that a real concern? That should be evidenced by real measurable data. And sometimes it might just be that there isn't a drop in productivity, but if staff are unseen because they're working from home, there's a perceived drop in productivity. And really, is it a drop in productivity or is that a managerial trust issue? So that's something to think about. The third one is a desire to maximize the value of commercial property, which I think if an employee put in a flexible working request, I don't think a business is getting away with that as a reason to reject home working or hybrid working. There are 8 reasons why you can reject a flexible working request. The only one that really would fall into would be it might cost your business too much. But again, I think that would be a hard sell to say you not being in the office is reducing the value of our property. For employees then, in stark contrast, it's the why not? I don't want to come back to the office. Now, there are some jobs, factory workers, train drivers who have to be in the office, but if you are a skilled worker in a high demand sector like tech or finance, you might prioritize flexible working and you might consider going to a job where flexible working is offered rather than one where it's not. And companies who fail to adapt risk losing that talent, so it creates an employee-friendly market and can create a retention issue for your business. There are increasing in costs. Everyone's feeling it. Inflation's at 3.8%. It's the highest it's been since January 2024. That means every lunch is more expensive. Rail fares go up every January. That's going to increase the costs. Your staff might say, well, it's costing me more to come into the office than if I stayed at home. When productivity growth is slow, like it is at the moment, wages also tend to stagnate. So your employees have got less money and more costs, which you can see the reasons why they wouldn't necessarily want to come back to the office. And on the flip side of productivity, many employees feel they are more productive at home, but that's not a one-size-fits-all thing. That splits on generational lines. Older workers tend to believe they're more productive in the office. Younger workers tend to believe they're more productive at home. As a paradox, younger workers probably need to be in the office more because of training, supervision, things like that, whereas older workers might well be able to crack on with their jobs at home. Some people say there are fewer distractions working from home than in the office, the water cooler chat, but that's not always the case. Some people talk about, for example, I've put well-being there, transition can cause issues with stress and anxiety. And equally, some people say, well, there are discrimination issues if I'm a carer for a child or someone else. But it should be said that childcare, working from home is not a replacement for childcare. But there is a fine line between that and discrimination if you are stopping someone, for example, picking up their kid from school. So what should employers be doing? Well, we've been through these before, but check contracts for employment. Is there a place of work clause? Did you hire them as a remote worker? Because if you did, it's going to be really hard to get them into an office 3, 4, 5 days a week. obviously have a hybrid working policy that's watertight, and be prepared for flexible working requests. Go through that business rationale. From April 2024, flexible working requests became a day one right. As Joe said earlier, those rights are going to get extended in 2027, and it's going to become harder and harder to reject flexible working requests because the government have said that flexibility should be the default. Measure outcomes, not presence. It's no point in your employees being in the office 40 hours a week if they're not doing anything whilst they're there, when they could be more productive at home. And monitor that, but obviously monitor it fairly, lawfully and transparently in accordance with any data privacy notice. If you're checking their Teams calls, their Slack messages, you need to back that up. And if worse comes to worse and you have to discipline people for not attending the office, make sure you follow a fair process and do consider any discrimination issues, such as the childcare disparity that I went through earlier. I'm going to talk about a case now. The case is For Women Scotland versus the Scottish Ministers. This case was from earlier this year. There's a bit of background. In 2018, the Scottish Government passed the Gender Representation on Public Boards Act. That set a gender representation objective for public boards, saying that they must have 50% of their non-executive members be women. So why am I talking about Scottish public boards to all of you? Well, it was challenged by For Women Scotland, who are a gender critical advocacy group backed by the likes of J.K. Rowling. And they said that that was in breach of the Equality Act because the Scottish Government's definition of woman included trans women, and For Women Scotland said that discriminated against biological women because it didn't mean you're hitting your 50% threshold. The judgment was passed by the Supreme Court on the 16th of April this year. What the Supreme Court did is they looked at the Equality Act, which doesn't define man, woman, sex, and they said, well, looking at this, it was always intended by Parliament that the Equality Act should talk about biological and certified biological sex and not certified sex, which means the sex you were born into and not what trans people identify with. And they gave examples of this by saying that in the Equality Act, only women can suffer from pregnancy discrimination or breastfeeding discrimination. And by virtue of that, the word woman must mean biological woman. It's worth noting that the Supreme Court reaffirmed that the ruling does not affect protections in the Equality Act for the protected characteristic of gender reassignment, and acknowledged that trans people were vulnerable members of society and still had the right to live their lives with dignity. Following the case, the Equality and Human Rights Commission released interim guidance. That guidance is no longer available online because it is due to be replaced very shortly by full guidance. The guidance is likely to be broadly similar to the interim guidance. So this followed the Supreme Court's ruling and said that trans women, in accordance with the Equality Act, are biological men and trans men are biological women. The guidance applied to schools, workplaces, sporting bodies, publicly accessible services, and basically said that services that are based on sex should be based on biological sex and not certified gender. How does this affect private workplaces like where you all work? Well, the Workplace Health, Safety and Welfare Regulations 1992 require all workplaces to have toilets that are separated for men and women, except where they are in separate lockable rooms. And the same goes for washing facilities like sinks, which means if you have a room with a toilet and a sink in it, that can be gender neutral. But most toilets in workplaces are a block of toilets, a sink outside, and that has to be separated by sex now. That means basically that your workplaces should be separating toilets for sex, not certified gender, according to the Equality and Human Rights Commission, because it's likely that any definition of sex in the workplace regulations, the Supreme Court would follow the same pattern that they followed in the For Women Scotland case. This creates issues, particularly if you have trans members of staff. MPs have recognised some of these issues and written to the Business Secretary. They've said, well, hang on a minute, we've always acted in a certain way, we've got male and female toilets, what do we do? Are we expecting employees to ask people to identify their gender before they go into the toilet? Are we having to create new gender-neutral toilets and changing facilities? And as an employer, you basically have three options. The first option is to go against the Supreme Court's decision, do what you were doing before 16th of April, and adopt a policy that allows people to use the toilet based on their identified gender. The second option is to implement the Supreme Court's decision and the EHRC's recommendations and say, we separate toilets based on sex as per the workplace regulations. Your third option is what the EHRC recommends, which is to create gender-neutral provisions in addition to men's and women's toilets. Now, that could be difficult from a cost point of view. The EHRC does say where facilities are available to both men and women, trans people should not be put in a position where there are no facilities for them to use. And it seems that the main suggestion, the main implementation, if you can't make an entire block of toilets gender neutral whilst keeping male and female toilets separate, is to have, for example, accessible toilets, like your disabled loos, accessible to all. My final topic is on the prevention of sexual harassment 1 year on. So since October last year, the law has imposed obligations on employers to take reasonable steps to prevent sexual harassment in the workplace. This is a proactive duty. It requires all employers to consider and manage the risks in the workplace. It includes sexual harassment from colleagues, but also third parties like clients, customers, or contractors or your suppliers. How successful has this been? Well, surveys suggest not particularly. 41% of employees have not yet carried out a sexual harassment risk assessment. 45% of businesses had provided sexual harassment training, but that does suggest that 55% hadn't. And 34% have provided no training since these changes came in. Probably most worrying for employers is in the first half of 2025, calls to ACAS about sexual harassment in the workplace went up by 39%, which either means that sexual harassment is happening a lot more in the workplace or employees are getting a lot wiser to their rights. That means that if you get a claim, not only could it be potentially damaging from a purely award point of view, but if you as a business have failed to take reasonable steps to prevent sexual harassment, that award can then be increased by 25%. In addition to that, the Equality and Human Rights Commission has the power to investigate businesses. This is with or without an incident of sexual harassment or a claim taking place, but mostly it's going to be if there is a tribunal claim or widespread complaints. And what they can do is enforce compliance through legally binding agreements, seek injunctions to make businesses comply with those agreements. This is exactly what happened to Lidl. So in August 2025, Lidl signed an agreement to prevent sexual harassment in the workplace, and they entered into a legally binding agreement to do all of these things, to run surveys, monitor risks, take complaints seriously, review previous complaints, monitor how its sexual harassment policy is implemented. And that's basically what all of your businesses should be doing too, because the Equality and Human Rights Commission has set out an 8-step guide that it recommends you all take, which is develop a policy, engage staff, set up a reporting system, training, handling complaints. The key thing here is currently, since October last year, you are under an obligation to take reasonable steps. So that is to do enough. With the Employment Rights Bill, that's going to be changing to take all reasonable steps. So that is doing everything. So that list It's not pick and choose. From 2027, you should be doing all of those things. You should be doing all those things anyway. That is the end of my section and the end of today's seminar. If you've got any questions and you're online, please do put them in the Q&A function. If you're in the room, come and speak to one of us afterwards. Just a final plug for our Myerson HR product, which is our fixed fee retainer that provides you all with unlimited advice for your business. And we've got some Myerson HR clients in the room, and I hope they see the value in it as well. So thank you for attending today, and safe journeys home. Thank you.